Welcome to the Business SOS podcast. This is Rich Sierra, President of Florida Small Business Legal Center. This is episode 72 of Business SOS. Thank you for listening today. Today we're going to talk about some 10 mistakes that business owners make. I've been doing that theme for the last few weeks, and I kind of like it, so I'm going to keep with that theme just to give you some actionable points that you can take with you as you listen to me, whether in the morning, afternoon, or evening. So I want to give you some tips that will help you navigate the legal challenges that you face in your small business. So today I'm going to talk about 10 mistakes that business owners make when going into partnerships. In my practice in the Florida Small Business Legal Center, this is my 20th year of practice. I'm very proud of that. And I've seen hundreds of partnership disputes. And they have a common thread. There's a common theme that they have and why the dispute happens in the first place. And there are mistakes that are made along the way. So I want to talk about that. And my purpose of sharing these tips with you is to help you avoid them if you go into partnership. And it's very common that whether it's a friend telling you, listen, I have this great opportunity to invest in this business, or perhaps, which is happening more often now, in which employees of the business are invited to invest and become partners of the business by the boss, by the owner of the company. And that brings all kinds of different dynamics and issues that I want to share with you in the case that you're in that situation, that you are a key employee, you're working for the company, and then the boss tells you, listen, we are looking for a partner. Would you like to join our company? And sometimes people do, but they don't really do the necessary due diligence, the necessary investigation. They go into these partnerships, they don't work out, and then they come to my office and say, what happened? And trying to unravel really the mistakes that were made along the way. So I'm going to go right into it. And the first mistake that I see, and it's a bit self-serving, and I apologize for that, is not hiring an attorney when you go into a partnership. If you're going to invest in a company, whether it's a minority shareholder or you're going to be a member of an LLC, or even if they're going to give you equity shares because of sweat equity, my recommendation is to hire an attorney right off the bat, because that attorney is going to protect you and work in your best interest. There are legal documents that will have to be drafted, legal documents that have to be signed and executed. And if they're not done correctly, then you might end up not having a partnership or ownership at all. And in fact, this is happening very often. In the last year, I've seen 3 or 4 of those cases in which people believe that they have ownership interest in a company, and they find out that they don't have any. They only have a piece of paper that says that they have ownership, but in reality, there is none. So how can we avoid that? At the very minimum, if you're going to invest in a company, if you're going to buy shares from your boss or somebody that you know, that you need to, my recommendation, you don't have to, is to hire an attorney that understands business law, understands these transactions, and can help you protect your best interest before you make that investment. So mistake number 1 is not hiring an attorney before going into a partnership for the reasons that I just mentioned, and for perhaps the mistakes that I'm going to be sharing with you today. Mistake number 2, not having a written partnership agreement or having an inadequate agreement. Repeat that. Not having a written partnership agreement or having an inadequate agreement. So I'm going to break those two points. Often people come to my office. I invested $50,000 in this, joint venture. I was going to go with my friend, and we're going to buy this property, and we're going to flip the property, and then go ahead and share the profits. Then what happens is that they invested the $50,000. The partner went ahead and flipped the property, did not give him the $50,000 back, and kept the profits. It happens more often than you realize. So the first question that I ask when somebody comes to my office and I said, do you have a partnership agreement? Often the answer is no. I have some text messages, I have some emails, I have proof that I sent them money, but we really didn't write anything. We want to save money. We don't have lawyers involved, which go back to mistake number one. If you think you're saving money by not retaining counsel when you go into partnerships, it is a fool's errand. I'm going to be very clear, very blunt about this. If you're going to spend 50 grand or any money in buying an interest in a company, it is in your best interest to retain counsel and spend a few $1,000s to make sure that that money goes in the right place and you actually have ownership interest, and also that you actually receive the return that you were expecting out of the contract. And that attorney will tell you you need to have a written partnership agreement or a joint venture agreement. There are different forms, but you need to have an agreement. So that attorney will tell you right from the beginning, have a written partnership agreement. If you're in a situation that someone tells you, send me the money, well, happens often as well. Go ahead and send me the money. Here's my wire transfer account number, and we'll do that later. I'm going to call my attorney to draft the agreement, but we need to get this deal done fast. So just send me the money. We'll draft it later. My recommendation is the answer is no. It's important that you have a written document outlining what the money is going to be used for, what you will be getting in return. And I've said this before, fast deals lead to problems. And that's a red flag. When there's an urgency for you to send the funds before a document is drafted or presented to you, that is a red flag, and you should consider putting the brakes on that deal until you make sure that whatever agreement you have that you made with that other individual, it is clearly described in the document and signed and executed. That is important. So do not shortcut these types of transactions. Another thing that I see here is having inadequate agreements. So the second fallback from not hiring an attorney and not having a written document, even though they ask for money, your people transfer money without any type of document, is said, we want to save some money, we don't want to get lawyers involved, so what we're going to do is we're going to go online and download some forms. And you pay $2, download some forms, they're available online, or you can get some free ones. You go ahead and say, well, sign this. This has every all the provisions that we need. Sign it. We have an agreement. And you find out that those documents do not reflect what you agreed to do in the first place. I've seen these documents and I'm like, well, what exactly did you agree to do? There's nothing here. They're only boilerplate provisions, and that's what these templates provide. They provide some boilerplate provisions that in most cases are customary to these types of agreements, but do not go into detail about specifically what you agreed to do and what you agreed to pay and what would you be getting in return for that partnership. So again, when I look at the agreement, there's just a lot of things that are missing. And my question is, what do you agree to do? And they're like, I understand the agreement. And I'm like, no, it's not. So, and these two, mistake number two, happens, often as a way to shortcut the process or save some money, quote unquote, of not retaining counsel. So that's my recommendation. If you're going to go into a partnership, make sure you hire counsel. Number two, have a proper written partnership agreement that includes the provisions of the agreement, but also provisions that will protect your interest. And in prior episodes, I went over the operating agreement questionnaire in great detail about what should be included in a partnership agreement. In this episode, I'm not going to go into that because I already covered that in a number of episodes past. But if any one of you listening today would like a copy of my operating agreement questionnaire as a basis, I'm happy to provide it to you. Just send me an email at rich@richsierra.com, and I'll happy to send you that email. Just put in the subject line, operating agreement questionnaire, partnership agreement. I'm happy just for listening to me today. I'll send that questionnaire to you, which really, there are questions that are in the document that will help you, that really brings a conversation to your partner or potential partner about things that you need to talk about. So that's a good basis to start. Mistake number 3, failing to define roles and responsibilities of the partners. This happens often. Again, if you're going to go into a partnership, it's because both of you or 3 of you will be able to collectively achieve more than one individual will be able to achieve in that business. So that means that each individual has a different skill set, that will bring the business together. All of you cannot be doing the same thing at the same time. It does not make any sense. So, you have operations, you have marketing, you have financial management. A key area that is overlooked often is that the decision-making authority. If the partners are 50-50 partners, you have to define, okay, who has authority to write checks, for example, and by how much? Who's going to be responsible for the operations of the business? Who's going to be responsible for the marketing and new business development? Who's going to be making decisions on the financial management aspects? Which vendors to contract? Which contracts to sign? What limits contracts you need to, one partner can sign versus 2 partners needs to agree upon. So those are the key areas that you need to have defined, but that comes out of discussion with the potential partner. Okay, are you going to be running operations? Who's going to be doing the marketing? What are the objectives? What are the goals? Okay, the financial management aspect. When are the bills going to be paid and how they're going to be paid? And who has day-to-day decision-making authority in the business in which aspects? And so that's important. And a problem that I see comes to my office regularly is that those decision-making authorities are not defined, and it creates conflict with the partners. Mistake number 4, not establishing how much each partner will contribute to the business and how much each partner will be paid. This is kind of a two-part mistake. And let me go to the first part, establishing how much each partner will contribute to the business. If the partners agree to invest, say, $50,000 each for 50% of ownership in the business, it is important that money is actually paid. And what I see happen sometimes is that one partner contributes to the business to make the capital contribution, while the other partner puts part of the money in, say $10,000, and they say, well, I'm going to pay the other ones in payments. But that was not the agreement in the first place. And that creates a conflict when one partner does not contribute the amount that was agreed upon while the other one does. So that is important, how it's going to be paid, whether it's a combination of 100% cash or a percentage of interest will be given to the partner based on sweat equity. Nothing wrong with that. It happens, but that has to be defined in the agreement and how that percentage of ownership is going to be allocated to that new partner. So you have to have those decisions made. And what happens sometimes is that they said, okay, I'm going to put $50,000 in the business as working capital. It's my capital contribution. You're going to be working the business, but you're still going to be 50% partner. Then the owner that is supposed to earn it through sweat equity does not do his job. And that's where conflict arises. So that has to be defined in the operating agreement or the partnership agreement. Salary. Whether the partners will be paid salary and how much. Clearly, if one partner, this is the day-to-day it's a full-time work of that partner. The partner should have some compensations because the partner is making a living, is working the business. How much of what will the salary be? That's something that has to be discussed. Otherwise, it will be a source of friction, and both of you or three of you should agree on the salary. One partner should not just decide, I'm going to pay myself X amount without consulting the other partners, because it'll create problems later on. And whether and how often to pay distributions, quarterly, semi-annually, annually. And the reason you want to have that established is because sometimes partners feel, okay, you know what, I did a great job. I'm going to write myself a check, $10,000, but they don't pay the other partners because the partner felt that partners didn't do a good enough job or they didn't do enough work. That creates a conflict. So if you get the theme here, is by not having these items in a partnership agreement, and people, if they act arbitrarily without consultation with other partners, that will create a conflict which could lead to litigation. Does not necessarily have to end in litigation, but could lead to it, and often it does. Number 5, not defining the percentage of ownership interest and which decisions require unanimous consent. I recently saw a purchase agreement for a business, and it did not have the actual define what percentage of interest. It said you're a partner in this business, but it doesn't say how much. So, and I noticed it was more of a downloaded document. And when I asked the clients, how much do you own in this business? What percentage of interest? It's a 50-50. And I'm like, okay, so do you have a membership certificate? It was an LLC. No. Do you have a K-1 report? And I'll go over that in a few minutes. No. And he's been, quote unquote, a partner for a number of years. Do you receive any checks, any distributions? No. Have you looked at bank accounts? No. Do you have access to them? No. So exactly what do you have? One document. There's no membership certificate, so you don't have specifically anything to prove that you're an owner. But in this particular mistake, we're talking about defining what percentage you may own, or the partner you may own as a new member into this company. So the document has to reflect that clearly. And also, if the document reflects that, say you're a minority shareholder or a minority member of an LLC, something to consider is what decisions require unanimous consent. Just because you're a minority member in a company does not mean that you have to agree that the majority member will make all the decisions, you'll have none. By agreement, you say, I'm a minority member for the purposes of distributions. However, for decision making, we will agree that any type of major operational decisions or purchases will require consent of both partners. So you can agree to that even though you're a minority shareholder or minority member. So I just want to keep that in the back of your mind. And understanding what decisions will require unanimous consent is important. And I'll give you an example. Selling a business often requires unanimous consent. Distributions, when and how much are they paid? Major purchases, or contracts. And I made the example, if you have to buy some, box of paper at Amazon, that should not require unanimous consent. It's something day-to-day operations. But if you're going to renew your lease for the next 5 years, that should require unanimous consent. It depends, on which business you're in or what the partners agree to. But I'm just giving you that example of any type of decision-making that will impact financially the business. And even if the partner is a minority shareholder, the partner can actually have some decision-making on that major decision for the business, and it can be codified in the agreement. And that's what I recommend. Another point here is that as we're talking about defining percentage of ownership, interest, and decisions requiring unanimous consent, uneven compensation is also a major source of friction between partners. One partner deciding I'm going to get paid X amount more than you, that's something that will bring a source of friction, which could create conflict. And those things can be resolved, beforehand. And as you're evaluating, and I said that's why I recommend the operating agreement questionnaire, because the questions that I ask, they elicit some conversations. And if you cannot agree on the questions that are asked, then you have to reconsider whether this partnership is actually beneficial for you. Because you're having a conflict drafting a document, you will have conflicts along the way with your partner. It's just human nature. But having those items already discussed beforehand, it will help you avoid conflicts and have a more smoother operation. Number 6, assuming that friendship equals a good partnership. It's okay to have partnerships with friends. Nothing, you got to like the person you're working with. But there's a misconception that just because you're close friends, you'll also become good business partners. It's a different relationship altogether. Certainly not going to go into that. I'm not a psychologist. But my recommendation here is that if you're going to go into partnership with a friend, an acquaintance, especially a friend, somebody that you know, it's very important to have a written document, just to have things clear. And you're better off having the difficult conversations about the partnership, the what-ifs, before you enter into the partnership, rather than going into the partnership, things are going to work out, we're fine, we know each other for a long time, shake hands, here's the money, let's go with it. And then what happens, things don't go wrong, and then we have to unravel this, and we have to deal without a document, which makes life a lot difficult for the attorneys, but also for you as the client as well. So have clearly defined areas of responsibility, clearly defined guidelines, and have a written partnership agreement that will help you maintain that partnership solid, but also the friendship. Number 7, not planning for dispute resolution. Disagreements between partners will happen. Could be minor disagreements. Hopefully they're all minor. They're just routine disagreements. And that tension is actually healthy for the partnership because there'll be new decisions that will come out of that tension. But if you have a major disagreement that requires a third party, the knee-jerk reaction in some cases is let's go to court. And I do not recommend immediately going to court simply because when you go to court, you're telling the judge, we cannot solve problems among ourselves. We're partners. We cannot solve the problem amongst ourselves. We need you to solve it for us. And I will tell you that the judge will solve it for you, but not the way you would like it to be solved. When you go to court, there will be a winner, there will be a loser. So there's no in between here. And it's very expensive to file a lawsuit or maintain a lawsuit. And I went over that in prior episodes, and I went over my litigation budget worksheet, and I went over some of the items that encompass litigation, how expensive it can get. So having in your agreement a mechanism where you actually have a dispute resolution process will be helpful. It also will be cost effective. And I'll just give you an example, some minor and major disagreements. I mean, purchases, large purchases, taking on loans without the partner's approval, or taking significant loans and getting the company in debt, and also hiring new employees or firing employees. Those are things that the partners that could disagree on, and it could be a source of friction. A mechanism that I recommend to resolve disputes, and this is something that should be, again, in writing, and I'm hammering this throughout this podcast because if there's anything that I want you to take away from here today, number one, if you're going to go into partnership, get a lawyer. Number two, if you're going to have a partnership, get it in writing. Those are the two key points that I want to make sure that if you remember do not remember anything else, remember those two. So a mechanism that I suggested is basically having a meeting to try to resolve the dispute between the partners. That's fine. And the second one, if that does not resolve, you need a third party to come in and help facilitate that disagreement or that dispute, is perhaps getting a mediator. Third party and mediator is a neutral third party. Could be a retired judge or another attorney that practices in the mediation field. You pay the mediator by the hour. 3 or 4 hours of mediation, you can get it resolved, and you can move on. And that's actually, if you do that at the beginning of the process, it'll help you save a tremendous amount of money, because if you file the lawsuit, you're still going to be required to go to mediation anyway. So you're not saving any money by, let's file the lawsuit first. Now, if the partner does not want to go to mediation, then you might have to go into a more severe step, which is filing the lawsuit, because then that will compel the partner to come to the negotiating table. But for that, you will need an attorney to assist you, and that's not something the subject today. But I like the idea of a step process, a mechanism in place that has steps to resolve the dispute, so it gets resolved at some point before a lawsuit is filed. Mistake, see, I might make some of these. Mistake number 8, not conducting due diligence. And this one actually should have been a little bit higher on the list as I was preparing my notes for today. This happens often when a new partner works for the company, because they think, I know the company, I'm familiar with it, I don't need to look at their financials, I kind of know what's going on with the company, I was the manager. If you're going to buy, one thing is to be an employee of a company, and the other one is to be the owner of a company. And the due diligence is completely different. So if you're an employee and you're a key employee of the company, and they say, we want to bring you in as a partner, they ask you to invest some money, my recommendation is to get counsel. And then I say, no, you need to we can use our lawyer. I see that happen, repeatedly. You can use our lawyer will do the paperwork, you're fine. Well, the lawyer for the owner and for the company is representing the company's interest and the owner's interest, not your interest. So a response is, you know what, that's great. However, I really prefer to have my own attorney to review it and give me guidance. And they should not be offended by that, because you're paying for that out of your own pocket. So you got to treat, even if you're investing as a minority owner of the company, you have to treat this as if you're buying into a company. And for that, there's a due diligence process that an attorney can help you with in evaluating the financials, profit and losses, lawsuits, any liens, the ownership interest of the company, the K-1s, tax returns. There's a lot of things that go on in evaluating a company that you need to be familiar with before actually buying into it. So a mistake that I see often is that people investing hundreds of thousands of dollars into a business do not conduct a due diligence, and they don't know anything about the company. And that's a huge mistake. So you got to treat us, you're buying into a company. And also a mistake they make is trusting, quote unquote, the owner of the company, that the owner will look into the best interest of the employee. Everything might be good intention, however, that everybody's going to pull out for themselves. So you have to look out for yourself if you're going to invest in a company as a minority owner. get your own counsel, do your own analysis, make your own decisions. And in some cases, I see people paying the investment in cash without receipts, without any documents. And it becomes a problem later on how to prove that the money actually was paid. I'm going to flip these two on my list. This is going to be mistake number 9, not having an exit strategy. Businesses, can be for perpetuity, but none of us will be here forever. Excuse me. So you need to have some type of mechanism in your agreement. How are you going to exit that company if you want to do so? If a partner wants to leave the company, it's going to be a buyout. It's going to be a buy-sell agreement. All these things have to be taken into account. I've seen some agreements that said if you leave the company, you relinquish your shares, even if you worked 5 years into the company. Surprising to see that, but some people don't read the documents, which, again, an attorney can help you with that. So there are many different mechanisms that are available, tools available to help a minority partner exit a company. But and often, in many cases, it's not included or there's no document at all. So that's why, we have buy-sell agreements, we have restricted covenants to sell. And also what happens if a partner dies or is incapacitated? What happens to those shares? And those are discussions that have to be had about what happens to that ownership interest in the case one of the partners can no longer work in the company due to incapacity or the person dies. Mistake number 10, last but not least, not receiving the proper documents which show that the interest was actually transferred. In some cases, I see what you own. You're a partner in this company, as I mentioned before. What do you have? They have one piece of paper that said, I bought these shares. So what else do you have from the company? Nothing. In some cases, I just get a wire transfer confirmation. I don't get anything else. Some of the documents that I look for, and they're not all comprehensive. You're looking for a bill of sale, stock purchase agreement, articles of incorporation, the stock certificate, whether they updated the IRS records to reflect the new ownership interest, K-1 reports at the end of the tax year to show who owns the company in terms of any distributions. So this is not a comprehensive list, but this is one of the things that I asked for. So these are the 10 mistakes. Again, my recommendation, if you're invited to be part of a company as an investor, a minority shareholder, LLC member, joint venture agreement, seek counsel. It's worth the money to get the consultation. It's worth the money to get the legal advice. And number 2, get it in writing because it will protect you, your interest, your investment. Again, this is good for today. I appreciate you listening today. This is episode 72 of Business SOS. If you'd like to reach, how can you reach me? You can send me an email at rich@richsierra.com. My website is floridasmallbusinesslegalcenter.com. We're at Facebook at FSB Legal. If you want to watch the video of this podcast, we're youtube.com/@RichardSierra. If you want to give us a call, my number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores. Also, remember to follow us, and you like the podcast, follow us. We're on Apple Podcasts, Spotify, or wherever you enjoy your shows. Appreciate a 5-star review. Remember, until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.